SJC-11533, Robert Rose, numbers 1 through 11, the Children's Hospital Medical Center, and others.
All right, let's proceed. Good morning.
Good morning, Your Honor. May it please the Court. Mark Itzkowitz and Carmen Durso for the plaintiffs, Robert Rose, number 1 to 11, child sexual assault victims of Dr. Melvin Levine in North Carolina. Your Honor, the plaintiffs asked this Court to recognize the duty of care, which the Superior Court would not. And that duty of care is that hospitals and physicians which receive notice that their physician employees have sexually abused their child patients owe a duty of care to all foreseeable child victims of sexual assault by the physician employee to report such allegations of child sexual abuse to the proper authorities.
Could you help me understand what it is that you're advocating for in light of the facts here? I mean, when are you saying that that Children's Hospital had a duty to warn regarding Dr. Levine? Was it only while Dr. Levine was employed by Children's Hospital? Did that duty continue? And where it was triggered by learning that he had committed certain acts?
It was triggered by learning that he had committed certain acts. The hospital learned as early as 1967. He had been employed there from 1967 through 1985.
So when did he have the when did the hospital, when are you saying that the hospital had the duty to report
1967 forward.
1967 forward, not ending at any particular time?
They had received the notice that he had sexually abused his patients in 1967. They failed to take any action whatsoever from that point forward. Had they reported to the proper authorities in 1967 or at any time up through the time that he was employed by the hospital until 1985, or when he left the hospital in 1985, then
You're saying it's a continuing obligation.
the continuing obligation.
All right, and then let me follow that up with just this. How would Children's Hospital have satisfied its duty of care? What notice and to whom?
They would have provided notice. There were a number of authorities that existed that would have investigated this. First off, there were internal hospital authorities to look into the doctor's ability to practice at the hospital. That would have been one source. Secondly, would have been the Board of Registration in Medicine.
They would have to have done all of these things?
They did none of them.
Oh, I understand that, but I mean, what are you saying would satisfy the duty?
Had they done any of these things to initiate the process, to look into the allegations, to effectively to report the information that they had received, which would have started a process of looking into it, investigating it, and thereby stopping it, that would have been sufficient. And they could have done that in any one of ways of reporting it to organizations and entities which existed at the time, which continue to exist. In fact, there are more of them today than there were back in 1967 looking into the same thing. And had they triggered that process, that would have satisfied the duty of care.
So when does this next emerge? 1967, there's some vague allegation of something being brought to the attention. We don't know what they did with that. You say they did absolutely nothing.
They did absolutely nothing.
Maybe they discounted it.
Perhaps
Maybe
they did.
discounted it. Okay. So when is this next surface?
Well, what we know is this, Your Honor. We know that every single year that Dr. Levine practiced at Children's Hospital, he molested child patients.
I
In fact, they've
understand.
been
When did it
identified.
next emerge as an allegation?
It next emerged as an allegation that we know of publicly. In 1988, when
Right,
suit was filed.
1988. So he's in North Carolina, licensed, practicing at UNC.
But we have an allegation in the complaint, and we haven't, this case was eliminated on a motion to dismiss, so
the
of course
duty.
there's been no discovery. On the duty issue, yes, Your Honor. So there's been no discovery, but we have information that would seem to indicate that in fact there had been additional reports during this time period. If in fact there were additional reports, I can't give Your Honor dates of that. That's
So
information.
anyway, with respect to the 1988, it surfaced, it was fully vetted and dismissed by a court, right?
It was vetted in a court, Your Honor, and my understanding is that when it started trial, One of the defenses, and indeed this is part of the reason why the duty of care is so important here, one of the defenses that Dr. Levine raised was that his contact sexually with the plaintiff in that particular case was an appropriate form of medical care.
I take it the judge found no liability after trial.
The judge found no liability because there was no expert testimony.
Okay.
And because there was-
the next time it emerges, there's a report to the Board of Registration of Medicine.
Correct.
No liability.
The board finds nothing.
Okay,
Yes.
so this is in the 1990s.
Yes.
So you're saying Children's Hospital had some continuing obligation years after he left and was under the employ and supervision of another state and another medical center to report these dismissals down to North Carolina? I'm just confused.
To report, to initiate, to act on the allegations. Okay, had they acted on the allegations back in 1967, the
Your whole case hinges on 1967.
Well, the 1967 is the point at which everything starts. Okay, 1967 is when they're notified of what's going on.
May I ask you this? Did they report it as a mandated reporter when they had reasonable cause to believe?
They did not.
Well, wait a second. 1967, was there a mandated reporter
mandated.
In
requirement?
1967, there was not. I understood the question to cover at any point in time.
When was that,
72,
72?
yes.
And as a mandated reporter, if you fail to do what you're supposed to do as a mandated reporter, is there a statute of limitations that runs as of the date of the failure, or does that toll the statute of limitations?
I apologize, Your Honor.
Yeah,
Statute
okay,
of limitations
1972,
civilly?
there's an obligation to report, failure to report.
Right.
40 years later, somebody brings an action claiming failure to report. Is there a statute of limitations on the claim of failure to report, or having failed to report, does it toll the statute of limitations?
No, I don't think that that comes up actually in the context of this case, Your Honor, and the reason why not is the abuse that actually would have triggered the lawsuit in the first place didn't happen until later. The negligence occurred earlier. The damages that followed from it didn't occur until later, and so the statute of limitations would have been determined as of the time the cause of action accrued. Cause of action didn't accrue until later. And so therefore,
Whose cause of action?
the plaintiffs in this particular case, Your Honor.
But the breach
The breach occurred earlier.
of duty occurred 40 years ago.
Yes. Yes.
And is there a statute of limitations on that?
No, there would be no statute of limitations in that sense, Your Honor, because, again, the statute of limitations comes up in the context of whether or not...
harm.
Of harm. And the harm didn't occur until later.
Let's assume for a moment that this doctor was a surgeon, and he was a surgeon at Children's for 20 years, and then left and went to North Carolina, was licensed there, was a surgeon in North Carolina for 20 years. But there had been allegations that he was negligent in some of his surgeries that the hospital was aware of. Would you say that the hospital would somehow be for, if these were not reported, these incidents of negligence would be forever liable to anybody he committed surgery on in North Carolina?
No, I would not, Your Honor. And I would not because we are dealing with something very specific in the context of this case. We are dealing with a question of child sexual abuse. And we're not talking, I know the defendants have been attempting to portray this as opening up all manner of floodgates and every employer is forever liable to everything. This case is not about that. This case is about a very specific type of harm. It's about a harm which the medical community and the general public has paid a great deal of attention to. It's a harm which, in the context of the ISCON case, actually there's language that would suggest that this is almost rising to the level of constitutional significance. And we are limiting the duty of care to that type of harm. And we're limiting it because the duty is based in large measure upon the community consensus that has arisen about the issue of child sexual abuse. That doesn't apply to negligence in general. That doesn't apply to medical malpractice in general. That's very limited, and that's what drives the duty in this particular case.
Is there any analogy between the sexual abuse cases that occurred in the church and let's say a priest left one state and went to another state, and would you make the same argument? that the church had a duty?
I would say that there should be, Your Honor, but I would say that that's not what's at issue in this particular case.
Right, there's no facilitation here. The hospital hasn't moved the doctor to another
No,
place.
it has not.
This is not facilitation
No,
in
the-
that sense at all.
That's right.
Is there, I couldn't quite tell, is it your position that there was no question, it's not part of your allegations, that when UNC hired Dr. Levine, that they didn't ask Children's for a reference that was,
That's right, Your Honor. There is a line of cases that if they had provided false information in a
That's
reference,
not
but
part of
that's
what-
not, we
that's
don't
not
have
part of
that information, so no, that's not part of this.
So,
It could break the chain of causation? I mean, if the doctor took 3 years off and sailed around the world, or if the doctor worked as a lawyer for 3 years and then went back to practicing medicine, is there a break in causation?
Not in this context, Your Honor, there is not, because what you're dealing with is, again, you're coming back to the original allegations, you're coming back to something that is driven by the seriousness of the issue that's being raised.
He became a social worker and sexually abused the children. The Children's Hospital would still be liable in your view?
That raises an interesting question, Your Honor, for this reason. The reporting that we're talking about is reporting within the medical community, okay? We're not suggesting that Children's has a duty to go search out every employer or every profession he might undertake to go into forever, or warn every possible patient he might ever come in contact with in the future. This is a matter that's driven within the medical community. Within the medical community, there exists, and there has existed for a very long time, first of all, a concern about the sexual abuse of patients that goes back 2,500 years. Secondly, a concern within the community about misconduct by physicians, which resulted in a determination by the medical community in 1958, a decade before he started at Children's Hospital, that the community, the medical community, would report physician misconduct. Sexual abuse of patients has been considered a form of medical misconduct, and agencies have existed to which the medical community would report for approximately 100 years. So there was a mechanism to put this in place, and we're suggesting that that's the mechanism that the hospital should have availed itself of. As a separate matter, of course, they could have reported this to the police, and the police would have done their own investigation, but we're talking within the medical community. If he leaves the medical community, as Your Honor's question seems to indicate, if he becomes a lawyer or a social worker or something else, the information that's been put into the repository wouldn't necessarily follow him into that confine. The hospital would have satisfied its duty of care by reporting into the repositories of information within the medical community, and if he then went off, molested a neighbor in a totally different context, became a lawyer and molested some client in a totally different context, the hospital would have not breached any duty of care in that context. This is confined.
now, you're not, to my knowledge, you've not alleged that Children's had knowledge of a pattern and practice of sexual abuse by this doctor, do you?
We don't allege that we don't allege that they knew of a pattern and practice, even though the facts would indicate that it was there. What we do know, and what the hospital would have known as well, is that reports of this type, this is a particularly recidivistic crime. If they
Well, you
get
say, I mean, what is a particularly recidivistic crime? That a
child
doc-
sexual abuse.
Well, I understand that, but the allegation, as I understand it, is that a doctor in examination of a male patient touched his genitals where perhaps that was not medically warranted. That's the allegation that you have, correct?
Correct.
Does a single allegation of that suggest that this doctor has a pattern and practice of doing that makes him a danger to other patients?
In 1967, based on that information alone, no. But had the investigation started in 1967, it could very well have led to discovery of the pattern and practice, which we now know to have existed. That's why the reporting becomes so important, because it starts the investigatory process, which could very well have ferreted this out. From 1967, when the hospital learned, Dr. Levine continued to practice for essentially 40 years. For 40 years, he continued to molest patients everywhere he went.
Why did you, is there any parallel action going on for your clients in North Carolina?
There is not, Your Honor. Certainly, we wouldn't be in a position to bring it, but my understanding from North Carolina Council is that they have a very unforgiving statute of limitations down there, and no, there isn't. The only source of recovery for these victims would be over here.
So you're saying on the basis of one allegation, there's an obligation to start the investigation?
Yes, Your Honor. Your Honor, if
Can you forever owe a duty to any patients this person ever has at any hospital from there
if they
on?
do not report it, yes. In this context, within this medical community, yes. Your Honor, if a patient came in with a contagious condition, and it was just one patient coming in on one occasion, and the hospital violated its duty to report, would there be any serious question that the fact that they didn't report this and the patient then goes out into the general public and infects God knows how many people would
Well, of
not
course,
give rise
wouldn't
to
it be a
liability?
verified,
I'm sorry?
a verifiable thing if somebody has tuberculosis or some other physical ailment?
Yes, and with proper investigation.
That's different than an allegation that something happened behind closed doors.
No, Your Honor, because both of them are only verified by investigation, okay? A person comes in with suspected tuberculosis, the doctor examines, investigates, as it were, determines that there's tuberculosis, and there's the contagious condition that needs to be reported. A patient reports something that amounts to child sexual abuse, the duty to investigate, the duty to report and commence the process starts. If the investigation had been conducted, it may very well have uncovered the child sexual abuse, may have uncovered the pattern that Your Honor asked about
But you're
40 years
saying-
earlier.
You're saying that it's an investigation. Couldn't it be an internal inquiry that doesn't have a report to anybody else, and they decide as a result of that that
Could there have
that's...
been, that would have been one potential, there's no indication that that ever happened.
Counsel, we're going to have to leave it there. Your time is up. Thank you.
Thank you, Your Honor.
May it please the court, Gail Ryan, appearing on behalf of Children's Hospital. Your Honors, this morning we're asking this court to affirm both decisions of the trial court in this case. The trial court allowed Children's Hospital's motion to dismiss the plaintiff's complaint on duty of care grounds, and also denied the plaintiff's motion to amend their complaint to add certain allegations concerning the duty they claim is owed in this case.
Can I ask you this? Let's assume for a moment that Children's Hospital became aware of a pattern and practice of this doctor sexually abusing his patients, but did nothing and was happy to see him go. Any duty there?
Your Honor, no, not in the traditional sense in terms of imposing a duty of care or an affirmative duty to warn or report. Now, I do want to be clear. Children's Hospital certainly has a duty of care to its own patients that it has never contested.
That's understood.
And from 1973, when the 51A reporting statute went into effect forward, there is certainly a statutory duty to report when there is a reason to believe that there's child abuse occurring and there's a specific child in mind. So there certainly are statutory duties if we're assuming that that allegation came forward or that practice or pattern was developed and became known to Children's Hospital from 1973 forward.
There's no duty under the statute governing the Board of Registration of Medicine to report to them?
No, Your Honor, not in the circumstances where there is a complaint made and there's no disciplinary action taken against a physician's license. Now, there's a comprehensive statutory scheme that governs and controls exactly how the Board of Registration of Medicine operates and exactly what hospitals are required to report to the Board of Registration of Medicine.
This isn't one, a complaint?
No, Your Honor, and there's no allegation in this case that at any point in time while Dr. Levine was employed by Children's Hospital between 1966 and 1985, that any disciplinary action of any nature was ever taken against Dr. Levine's license that would have triggered a reporting requirement to the Board of Registration
Right, but you certainly have an obligation as of 1986 under General Laws, Chapter 112, Section 5F, to report to the board when there's a reasonable basis to believe that there's a violation of the board's regulations, including gross misconduct by a doctor.
Well, that's correct, Your Honor, but 1986 is a year after Dr.
I understand
Levine.
that, but I mean,
Sure.
but you certainly have the obligation today to do that.
Well, correct, Your Honor. Certainly, if there's allegations of gross misconduct, there's several duties at this point in time. as the
Okay, but so
statutory-
let's go back to Justice Cordy's question. Let's assume that you have a doctor, and again, I'm not suggesting these are the facts here, who you know, based on your internal investigation, has a pattern in practice of using his physician practice to see young children who are vulnerable by nature, to engage in sexual misconduct with them, and that the fact that he is a doctor is enabling that trust and that relationship. And you know he's about to leave to go to a different hospital. You have no obligation to report that to somebody so that he does not continue this pattern in practice and endanger the, at least the mental health, if nothing else, of patients in the future?
Your Honor, there's a statutory duty, absolutely.
Okay,
under
how about,
51A.
how about a duty of care?
I don't believe that there is a duty of care to the future victims under that scenario, if I'm understanding Your Honor's question
Okay, and,
properly.
and why wouldn't you? Why would a hospital not have an obligation when it knows that that it has information which may not be known to others? That a doctor is a danger, either because of sexual abuse or because he's actually Dr. Death. He's affirmatively killing patients. You've no obligation to report that, to prevent him from becoming a doctor and being in that position.
Well, there are certainly statutory duties, Your Honor, but there is no affirmative duty in whether we're looking at this through the lens of general employers or specifically hospitals.
I'm referring to hospitals. You have special obligations as a hospital. You're licensed and you have the Hippocratic Oath, which governs you. No obligation. A hospital can say, it's not my problem. He can go out and he can become a doctor elsewhere, even though I know he's going to be endangering patients.
Your Honor, there's no obligation to affirmatively reach out to a prospective employer, to a prospective hospital, to make that affirmative
How
phone
about,
call.
how about to the Board of Registration here to make sure that he loses his privileges as a doctor? And I trust that in medicine as in law, if you lose your privileges in Massachusetts, you'd probably have reciprocity elsewhere.
Correct, Your Honor. If there is substantiated gross misconduct, that will trigger some sort of disciplinary action within the hospital. And as soon as a disciplinary action is triggered, absolutely, there is a duty to report to the
Okay,
Board of
but
Registration
and let's
of
assume you
Medicine.
don't. Let's assume you don't. No liability, even if, I mean, no liability if the person then goes on to continue that misconduct elsewhere.
Not to the future victims of the harm, Your Honor. Now, there is liability. The Board of Registration of Medicine, quite frankly, could withdraw the hospital's accreditation. They could take several steps against the hospital, and that certainly is the case. And there's several remedies available to the Board of Registration of Medicine to take action against the hospital. But no, not to the victim down the road, in this case, 47 years later after the
Well-
complaint was
But
made.
if you, in that scenario, if you, you recognize there is a pattern in practice, but the doctor says, you don't do anything because you know the doctor is actually moving to North Carolina and you are very happy to see him go. So you do nothing. You don't report it to the board, you don't do anything. Would you be liable, though, for, under some sort of negligent hiring or negligent retention of somebody? In other words, to the future patients, because you've let him now go, you said nothing, and arguably it would have, you would have, if he had stayed, you would have been required to take actions.
Well, Your Honor, as soon as there is an event that leads to a disciplinary action, right then and there is a duty triggered to report a disciplinary event.
But what if he leaves before you started? Then you don't have any duty to anybody, is that right?
Well, Your Honor brings up negligent retention
That's what
type
I'm just
theories.
asking. Would
So-
it be?
So there are certainly duties to the patients of the hospital, in this case, Children's Hospital. But no, Your Honor, to answer your question, no, there's no affirmative duty to those victims down the road. And there simply can't be, Your Honor, in terms of how that duty would be enforced. And that is a major problem in this case. We're talking about victims who, some of whom allege they were abused 21 years after this particular doctor left Children's Hospital employ. Where is the sensible stopping point if the law was to recognize that this duty continues infinitely down the line? And that's simply the reason, Your Honor, why there cannot be these affirmative duties extending out into the future with no parameters or timeframes or no reflection of geographic realities and temporal realities.
Are there any, I didn't get a chance to ask Mr. Iskowitz this, but is there any state in which a court has held something that's equivalent to this, to your knowledge?
No, Your Honor, I'm not, to my knowledge, I am not aware of any other court that has ever held the limited holding that the plaintiffs are proposing and seeking in this case. And I'm only aware of one other state that has ever considered this duty of care that the plaintiffs propose, and that's the Wisconsin Supreme Court, which in the Hornback case looked at a very similar set of factual allegations. In that context, it was dealing with the church and teachers. And there was a man who taught in Wisconsin in two different school systems, both run by, one by the Archdiocese, one by the diocese. There were allegations that he abused students there, and the diocese took no actions whatsoever to prevent him from teaching, to reach out to prospective future employers or prospective future victims. He then proceeded down to Kentucky, several states away, just like we have in this case. He abused his students in Kentucky, and it was those students in Kentucky that filed suit against the Archdiocese and the diocese in Madison, Wisconsin, on a theory that they did not reach out and affirmatively warn. And there was a whole list of people that they proposed that they should have affirmatively warned. The plaintiffs themselves, the Archdiocese down in Kentucky, and they failed to do all of that. And the Wisconsin court looked at the case actually under general principles of negligence law, because Wisconsin takes a much more broad view of negligence than we do here in Massachusetts, as opposed to the special relationship analysis that we would urge this court to consider this case under. And they found that it's simply too far removed temporally and geographically to be holding previous employers liable for failing to warn of sexually dangerous former employees decades into the future.
On the question of temporal association or relevance,
Yes, Your Honor.
are there any cases that have dealt with the failure of a hospital to report to a comparable entity such as the Board of Registration in Medicine, the failure to report misconduct to that board, a clearly defined duty? Is there a statute of limitations in tort that applies to the failure to report?
Your Honor, I'm not familiar standing here today with what the statute of limitation is in terms of failing to report to the board. I imagine there may very well be one. I'm not familiar standing here today. The statute of limitations grounds was not a ground on which we moved to dismiss, and it's not a matter that's been fully briefed before the court. So I don't know standing here today, Your Honor.
Under Irwin versus Ware, a police officer has an obligation to prevent an intoxicated driver from continuing to drive. Why should you not have a similar obligation to prevent a sexually abusive doctor from continuing to doctor?
Under Irwin versus Ware, they analyzed a statute in which they found that and it was not contested in that case, Your Honor, that the police officer at issue had an affirmative duty as a police officer in the course of his employment to enforce the laws for the general protection of the general public. Now, in this case, certainly once 51A went into effect, there is an affirmative duty to report for all mandated reporters, of which hospitals are one. But the purpose of the hospital is not to enforce the general laws and provisions of the Commonwealth. Certainly they must comply with them, Your Honor, but that is not the purpose. And I think that's an important distinction between our case and the case in Irwin v. Ware, where the court found that there was a special relationship between the police officer in question and the general public. There's simply no analogy in this case.
And how about the Hippocratic Oath to do no harm? Does the hospital not have an obligation to ensure that its doctors do not do harm to other patients when they have knowledge that there's a pattern in practice of that?
Well, Your Honor, I don't feel that that's a sufficient basis to impose such a broad-based duty. Certainly, the Hippocratic Oath guides the ethical community, just as there's a code of ethics for attorneys in just about every other profession. But a breach of a code of ethics, for instance, if we were here dealing with an attorney who stole client money while working for a firm in Boston, voluntarily leaves, goes down to a firm in North Carolina, and steals client money down there, well, certainly stealing client money violates an attorney's code of ethics. Certainly, it's a criminal offense that could be reported to the police. But that's insufficient, Your Honor, I would suggest, to impose a broad-based duty such that the North Carolina clients could then come up to Boston and sue the Boston-based law firm for failing to report those allegations of theft of client money.
But our sexual offender laws suggest that sexual abuse or sexual predation is a psychological condition, and that's more like, well, theft is not. I mean, we treat sexual abuse a little bit differently under the law because which is one reason we have a sexually dangerous person law. Does that not distinguish it from the theft example you give?
Your Honor, I would go back to the fact that 51A is been in force here in the Commonwealth since 1973. And the allegations in this case, if proven to be true, and we're here assuming they are true, even though Children's does contest those allegations vehemently, but we're here assuming they are true, would have been reportable events under 51A from 1973 forward. However, the 51A statute is a statute, it's not just any statute, Your Honor, it's a statute that the Massachusetts State Legislature has revisited on numerous occasions over the past several decades. They've added to it, amended it, altered it. They have never imposed a private cause of action. And I would suggest, Your Honor, that in the absence of establishing a private cause of action, there simply is no community consensus around imposing that duty, nor may this court, or nor should this court, impose that duty where none exists presently under the statute.
Thank you, counsel.
Thank you, Your Honors.